But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit it with a bat, hit him with a bat.
Judge, again, I'm not complaining. Been on the case 45 days.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list.
The state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday.
Also, would like to renew my motion for a statement of particulars. So that
I was right.
I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. That's our case. That is an evinced, depraved mind.
but they allowed her to shower since she hadn't had one. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart.
Snacks. Oh, Julie! Way to rub it in Sarah Boone's face. Julie's like, haha, bitch, I got the snacks. It's what you don't got.
With regard to the or tennis motion, as to Ms. Boone's request for snacks, the or tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate.
The judge is like, listen, state, I see that you're objecting to item blah, 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 but I don't know what the hell you're objecting to because I don't know what these items are. And the state's like, well, you know, sometimes I get motions that come directly to me that I see that aren't going to the court. So ask the defense team. And the defense team is like, well, okay, hold on. Let me look through my stuff really quick. Hey, Barbara, you got the stuff over there? Oh gosh. Okay. You know what, Judge? Can we talk about this later? So a little bit of disorganization, probably because there's so many people working on the team and they have so much work. Hi, can you see my dog right next to me? He's being so nosy right now. Are you being so nosy? You're so nosy. He's trying to steal my sandwich. That's why I haven't eaten my sandwich yet. You already got a little tiny piece. That's all you get. So today, we're going to continue with, I believe it's with the objections to the evidence. It was the state objecting to the defense's evidence, and then I don't know if it's going to happen the other way around because I think we already did that yesterday. And then someone, shout out to Gundam Girl in my Discord. Stop it, he's trying to steal my food. Shout out to Gundam Girl in my Discord who kind of like gave me a little bit of a recap of what happened today. So it seems like they're going to continue addressing that motion and then maybe discuss snacks because Sarah Boone wants to have some snacks in the courtroom. I mean, she asked for 2 juice boxes, some Pop-Tarts, some peppermints, some chips, and I forgot what the other one was, but basically all junk food, okay? I'm like, just have a nice breakfast, have a good lunch, and then have a great dinner. You know, you don't need to be snacking on like all that junk food or whatever, but you know, having candy in the courtroom is kind of nice, especially, you know, if you're kind of just sitting there bored and you want some flavor in your mouth, I guess. I don't think there's anything wrong with candy in the courtroom.
Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. So what we were asking for is, in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid, was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear. Since the
I thought that's what the judge ruled, because he implied that in order to when you have a self-defense, when you have a self-defense argument, with that comes with the privilege of being able to, you know, talk about the other person's characters, their prior bad acts, talk about like the injuries and all that stuff. I remember him saying that, and then I remember the judge ruling that unless Sarah Boone testifies, then the expert is not able to mention anything about battered spouse syndrome. That's what I remembered. The
motion is titled the battered spouse syndrome evidence, but the the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent during the testimony in the trial.
That was my takeaway.
Okay. He's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916-750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on particular occasions, section 90.404 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Here's the thing, though. What is going to be the overt act that the defense is going to put forth? Because yesterday he mentioned, well, the overt act could have been Mr. George sticking out his fingers out of the suitcase. And I was like, but he was trying to get out. He's in a suitcase. He's trying to unzip himself. If his fingers were even out, if we even believe that the fingers were even out, which I don't believe the fingers were out. Because remember, the detective said that if you look in the video, it seems like the zippers are kind of like closed shut. It doesn't look like there's any gap for anyone to stick any fingers out or anything like that. I don't know. I mean, he went up there and conceded pretty quickly. So let's see if the defense came up with something. Like, Sarah, give us something, okay? Give us something. Or maybe go up there and, maybe change your testimony. I'm not saying they said that, but, I feel like that's what she's going to have to do. We read a motion that was filed by the state yesterday where the state essentially said that Sarah Boone admitted it to the expert. I don't remember if it was the state's expert or the defense's expert, but basically the one that does the evaluation to see if they qualify for battered spouse defense. And Sarah Boone told them that she hit George with a baseball bat, but I think she minimized it because I think she hit George all over in the suitcase. I think she beat him. However, she said that, I hit his fingers. I'm like, I don't know if I believe that. I don't know if you hit just his fingers. I think you know how sometimes when you lie about something and you'll tell the truth about like a small part, but then you'll deny the bigger part. But you think admitting just to a small part is good enough for the other person and that they'll believe you. Like, oh my God, this person admitted to doing this. Well, I guess you must be telling the truth. No, I think Sarah Boone, I think she beat him, man, because he had like a ball on his head. He had like bruises all over. Because here's the thing. This is what we're getting so far. And Sarah Boone, when she goes up there and testifies with her evidence and all that, she needs to do a really good job at painting the picture that she was a victim. Because from what we're seeing so far, and probably because we have more information because of the letters and all the batshit crazy stuff that she's been doing after getting arrested. But the picture that we see so far is that Sarah Boone seems like an aggressor, but also a victim at the same time. She seems like the type of person who was very controlling of George. George didn't have a phone. I don't know. The state brought up, something about George not being able to look at porn, that Sarah Boone would accuse him of like cheating. And maybe he was, I don't know. And that, it seems like if George wanted to call his family members, if George wanted to do anything, it had to go through Sarah Boone. She had to be the one that cleared him, whether it's like using her iPad, using the phone. I don't know. It seems like it was kind of a controlling relationship. Like, I'm sure George fucked up. And I'm sure Sarah used that as ammunition. It's like, hey, George, you're a fuck up. So allow me to control your life because you're such a fuck up. You're unable to do it yourself. I'm going to do it for you. I'm going to take care of you. But I think she also used it against him, I don't know, but that's the picture that I'm seeing right now. Now, it could be different when she testifies. Maybe we'll see a different side. But, initially I just thought, okay, they're both just abusing each other. They seem batshit crazy. But, yeah, that's what I got. We now have a panel of jury to proceed with opening statements tomorrow. However, we have to do another hearing tomorrow before the opening statements happen because we are wondering, did the defense commit a discovery violation? We're going to have a Richardson hearing tomorrow to see whether or not the defense did, because apparently they gave the state 81 pages of some stuff. And then later on today, there was a thumb drive with over 90 something images, I think. And the state's like, excuse me, hold up a second. this is not what y'all provided me before. This is different. So the state wants to conduct a Richardson hearing just to see whether or not the defense committed a discovery violation. So this has to do with a Winter Park Health Advent. This is treatments that Sarah Boone was getting starting from 2018. The state said they got like 119 pages, said 90 earlier, 119 JPEG photos. And it wasn't like one PDF with like 119 pages. It was like 119 JPEG photos where they had to reorient everything. And they were like, this does not seem to be what was provided by the defense previously. What the fuck is this? Oh God, what a mess. What a mess. So now the judge says they're going to conduct a Richardson hearing, and here's what happened. Oh, I wanted to mention, at the hearing, the trial judge will be required to decide, 1, whether the violation was accidental or willful, 2, whether the violation was trivial or substantial. So was it a big deal? Was it not a big deal? And 3, the extent to which the violation impaired the accused's ability to prepare for trial. In this case, since it was maybe done by the defense, this would be the whether or not the state was impaired by preparing for their own case. So we'll figure it out tomorrow morning, bright and early.
They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Ms. Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be, and we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
Okay. At this point in time, the court is going to proceed with a Richardson hearing. Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27, 2024. The state had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided.
Judge, the 81 pages that
The 81 pages are not at issue.
I understand that they were given Sarah from the Advent Health report.
I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the...
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things?
That's, I don't know.
Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
Okay, so now on to the other issue with yesterday's issue that was raised by the state. Mr. J, poor Mr. J sitting right there. He was like, man, like 2 nights ago, I had like 550 pages of like shit, and then most of it wasn't even relevant. What's going on over there, Mr. Owens? Mr. Owens is like, well, until my client testify, I'm not sure what's going to be relevant. I think that's what I remember from yesterday. I think that's what I remembered.
Is this the Advent Health Winter Park Jorge not yet received by the defense? The state's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The
Owen says, I want all 550 pages in.
court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages? That those,
Yes.
The DAC and the narrative are on?
That's what's going to be offered into evidence at this point in time.
Yeah.
We'll work on that right now.
Appreciate it.
I've got staff. You're in the courtroom.
Here's what I'm thinking. I think the state, or I think Mr. Owens thought the state was going to sift through the evidence of 550 pages and then pick out which one was relevant for the defense himself. Is that why they didn't do it for the state? Mr. Owens like, oh, you want that? Okay, I guess we'll go through 550 pages and we'll just figure out which one's relevant. I don't know. Maybe he was expecting the state to do that themselves. And the state was like, no, that's your evidence. You do the work. You let me know what's relevant and what's not, and then provide me the relevant ones. Don't give me 550 pages with only 5% of it being relevant. I'm not going to go through all that. I have a lot of work to do. Now, if you thought the state or if you thought the defense wasn't done sending Mr. Port J over there a shit ton of evidence, we got more. Mr. J is like, man, last night at business hours, I got 300 plus pages.
Last night, after business hours, I received 382 pages of jail records.
More records? Oh, poor Mr. J. Mr. J's like, am I going to be receiving hundreds and hundreds of pages every night during jury selection?
Records regarding Ms. Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health.
Wow.
And the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would
I wonder if that's a tactic sometimes. Like, you know what? Let's just inundate the other side with a fuck ton of paper. Send it all, relevant or not, send it all. Or it's like the defense, you know, they were too lazy to go through it or didn't have time to. So they're like, you know what, let's just send it over for now. Just send it over for now. Let the state deal with it.
I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 22320, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed, there's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020.
Someone mentioned this yesterday, that maybe the defense is just trying to inundate the state with so much shit that the state will be like, you know what? Okay, maybe we need to continue it. Not going to happen.
And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torres's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
Oh my God, Mr. How many times are we going to go back and forth? You know what? Remind us. How long have you been on this case again? Just remind me. How many days have you been on this case?
Addressed that yesterday. It's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that. But generally, you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant?
I'm trying to tell you.
What specifically is relevant? What page? What date? What document? You're not answering my question, Counselor.
I didn't say we were going to introduce these records.
They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing these exhibits, this exhibit into evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all
When you have the stellar child and then when you have the troublemaker child.
three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper? If she has not reviewed these records yet, when do I get to depose her? Who's going to pay for the expedited costs for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post-deposition, post-evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. and then we took her deposition either the first or the second. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course experts can rely on inadmissible evidence if within the course of that area of expertise it's the type of evidence that's routinely relied upon. But how are these records relied upon if they acquired them after we've done all the depositions? Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. And we would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Harper review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we're going to take another deposition. So I'll wait. I will not ask for a review.
Okay.
So Mr. Owens is like, no, we don't want to do another deposition. It's fine. I will tell Dr. Harper to not rely on these. We're good. We're fine. Let's move on. All right, nice.
Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence.
Well, I remember that they told her she was not allowed to put makeup on because the jailhouse didn't want to deal with it. She's got eyeliner on. I don't know what happened. Maybe they're just doing it anyways. Fuck the judge's order.
Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-O. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, we anticipate is going to testify for the state, and he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect.
So he said something about Brian Boone is going to testify for the state for the defense. He might be an adverse witness. So we need to possibly establish some bias.
For impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son, and has had full custody for 4.5 years. That was not the agreement they originally had.
Him not being compliant on some orders. I'm not too sure what orders. And then he has custody of the son.
And he was ordered to pay alimony, which he has failed to do as a result of being incarcerated. So there's litigation going on. Brian Boone has counsel, Sarah Boone does not, and that divorce of their...
What does the non-payment of alimony have to do with what's happening in a family case?
Well, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased. And to show that he's biased, that he has not paid alimony for her.
So he's biased against Sarah Boone because he didn't want to pay her alimony?
$1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards Sarah Boone.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues.
If you were Brian Boone, would you want to pay alimony to Sarah Boone, who's been incarcerated? Would you want to give her child support if she's incarcerated and not taking care of the son? Fuck no.
It sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No.
Oh, did she want her alimony while she was in jail so she could use that money to buy things from the jail?
Oh, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into, under cross-examination.
But it sounds like there's pending litigation including a relocation and I don't know because it's not my case. I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Can you all approach this for a moment?
Owens submitted 550 pages of the.
I thank you all both for your arguments and clarifications. Based on the court can overrule the objection at this time for the reasons discussed at sidebar.
Now, I think this next part was maybe the highlight of today's hearing. It's going to be Mr. J for the state versus Mr. Owens for Sarah Boone's defense. And Mr. Owens goes up there, and when you start off the sentence as, oh, Mr. J's a smart guy, and he's a great attorney and all, ... something's about to go down. We got to see not interaction. We got to see what's the word I'm looking for? Reaction? Reanimated? Oh my God, a reenactment. We get to see a reenactment of what Sarah Boone did to George based on the state's understanding of what happened.
Yes, sir.
Are Court TV and Law and Crime, are they both streaming it? I didn't see it pop up.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in.
You were forced to disclose the overt act? Barely. You mean the fingers? The finger thing?
With the self-defense. And so tactically, he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is...
Wait, that was the best that they had? The fingers? That's the reason why Mr. Henderson didn't want to say what the overt act was? I thought it was because he didn't know what the overt act was. I thought he was just like, I don't know, I wasn't there for the deposition. I have no idea. It seems like maybe they did know, or maybe he didn't know and Owens knew. And they're like, fine, reveal the Holy Trinity.
The state. Tactically, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone, and state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission, that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can...
Oh, God, is he going to go back to wanting the... Do you remember Mr. Owens who wanted there to be a... what was it called again? Oh, fuck, what was it? He wanted the state to provide them with a statement of facts or something like that because he wasn't sure what angle the state was going to take at, what they were alleging. I don't know, to me, I thought it was pretty clear, but he wanted to have like a statement of facts or whatever it's called. And then the judge was like, no, I think. Or did they allow him to give, or did they allow that? I don't know. I feel like I'm hearing this argument. I feel like we've heard this before. All right, let's see where he's going. Statement of particulars. Yeah. Is that where we're going?
Everything, because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that
I was right. I'm a psychic. Or I pre-watched this. Okay, I'm pretending like I didn't know he was going to ask for a statement of particulars. Okay, all right. Sorry. My breakfast is processing right now. I'm absorbing all the sugars here.
So, in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day, and that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. Mm-hmm. And it goes directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Mm-hmm. Any response, Mr. J?
Mm-hmm.
Yes, sir.
Yeah, Mr. J. Mr. J is like, I'm ready. I'm ready.
Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games, it was Sunday fun day. He gets into the suitcase, we're all laughing, I zip it shut, we're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day, and she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers, and now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torres in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. They weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do, and we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down, because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day, and right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony, unless there is. Then that's a whole different bag of worms. Mm-hmm.
There might be. Guys, remember, Sarah Boone had 4.5 years to come up with this final version of the story. 4.5 years. 4.5 years. No more that it was an accident. No more it was an accident. It's like, no, I was triggered. I did it on purpose.
But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in prior violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12 4:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby, seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter.
Oh, you know this is going to be in his opening statement, because I think because we thought the trial was going to happen so many times, he probably practiced his opening statement. I feel like this is definitely going to be an opening statement. He's doing such a good job at it.
Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah, shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether
Ooh, I got goosebumps just listening to him say that.
he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, George Torres died from positional asphyxiation and the asphyxiation from being in a confined space, and eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, and committed.
That's what I said. I was like, we have new things now. Like she said, I don't know why she would admit to all these other things. I guess because she really wanted to show that she was triggered, and in order to show that she was triggered, she had to show that she acted on being triggered. But I feel like it made it worse for her by giving a statement about how she beat him while he was in the suitcase with a baseball bat and all stuff, and shaking it and flipping it. Like, we knew the flipping part because it was in a different orientation depending on the picture of the video you look at. But she was like, oh yeah, I also did this, I also did that. I'm like, wow, you just really made it way worse for you. Good luck. Good luck with the jury.
Violently shook the suitcase, threw it upside down, hit him with a bat, and committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
Yep, and Mr. J is like, wasn't it obvious? Wasn't it obvious, Mr. Owens? You don't need a statement of particulars. Get out of here.
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, State Senator. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Werner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors.
Okay.
The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone.
Oh, do they not have a person there that transcribes it?
We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Warner.
Oh, man.
And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess.
Yes, sir. I'm just making sure I'm clear on 60.
I feel like when an attorney gets badly owned, they do a really good job at acting like they didn't and acting like, see, I told you I wanted that from day one. You could have just given it to me. You could have said that to me in day one. Had you provided it to me. Oh, gosh. But you see, Mr. J did way too much of a good job there. It was too much of a good job. So I do think that she is going to tweak her testimony. I don't think she's going to say that she was like triggered and then out of rage attacked George with the bat. I don't know. I think she's going to try to say, oh man, so like I was triggered and I was like worried and like I flipped the suitcase. And then that's when I realized that his fingers were coming out and I didn't know what to do because like he was telling me he's going to kill me, he's going to come after me. So I had to take the baseball bat. I had to hit his fingers to make sure he doesn't come out because I was so worried. Oh my God, I had no idea what I was doing. I don't know, man. I think she's going to like tweak it like that. I think she's going to make it seem like she was really scared that the fingers were coming out and that she was about to be killed at that moment. Because Mr. J did a really good job at showing Sarah Boone being a triggered as depraved person that when she was triggered, she started beating him crazy with a baseball bat. But I think she's going to change her story. She's going to change her story. Than what she said in the meeting with when he was talking about when she met with the state's expert. Oh man, because I think she probably just saw what a good job he did to convince the jury.
They meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit.
Well, here's the thing: when people are impeached, they're just like, "Oh, I don't think that's not what I meant. I didn't mean it like that. It sounds bad, I know, but that's not what I meant."
List, which was any and all relevant reciprocal discovery to be obtained through ongoing.
Liars don't care about impeachment, man. Liars will lie all day, every day. They don't care about impeachment, okay? They do not care about impeachment. They'll lie every day, all day. Look at Amber Heard. Lied all day, every day on the damn testimony, And then when they were trying to impeach her, she's like, well, like, especially trying to get her with the audio recordings. I didn't mean it like that. That's not what it says. It's like everyone can hear what exactly it says, your tone, your voice, everything. And they'll still go up there and they'll continue to lie and act like nothing happened.
Investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed.
I believe those are the same witnesses that they've listed in regards to the prior incidents. The deputies that went out on the call-outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that
What does impeach mean? So if Sarah Boone testified on the stand and the state finds that she's lying about something, they can impeach her lies on the stand with her prior statements that she made, whether it's like interrogations or whether it was like in depositions. So if she's lying about, let's say she said, oh, I went to bed last night and I went to bed. It was fine. I wasn't triggered. Well, the state could be like, well, actually, in your deposition 2 years ago, you said that you were triggered. What do you mean? Are you saying you're not triggered, that you weren't triggered? Because you're saying different things now. So that's basically what impeachment means. And then also someone said, why do I think she recorded initially? Because I think she wanted to humiliate him. I think she thought it was funny. I think she's just a sicko and she's fucking stupid. She forgot that she recorded it. They even tried to delete it, it seems. It seems like she even tried to delete it. I think she's just sick. She's just a sick person.
Is that accurate, Mr. Owens? That October 3 states list?
We don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Judge, again, I'm not complaining. Been on the case 45 days. As we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose them. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial, Sarah Boone has a right to testify, Sarah Boone has a right to appeal. I believe those are the three fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them, and it may not. We may not call many of those that she wants to, but I believe my right to do that and to.
Look at her face. Look at her face. How dare you not call the people that I want you to call? James Owens, like, it's my right. If I don't want to call those people, I mean, they might not be relevant.
Present our defense with our witnesses is paramount, and she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations.
Hashtag Sarah Boone. Hashtag we can't hear the defense. Hashtag fix the audio. Hashtag turn your microphone on. Hashtag Elaine.
So the ruling remains the same. Court's going to reserve, address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave him this morning.
That is correct, sir.
Now for the final motion, we're requesting the snackies. Let's play a little clip from court TV so you guys know. Poor Mr. Owens had to go up there and request the snackies because Sarah Boone was like, I want snacks. But not only regular snacks, I want Pop-Tarts, I want juice boxes, I want peppermint, because I'm special. I'm a special person. Other inmates, they don't get that.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning, and then of course she's brought up around 9, and then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one.
That's good to know. Okay, she got to shower.
She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy.
I mean, the peppermint makes sense because, when you're over there with your attorneys, the paralegals, the assistants, you got to whisper things over to them. You don't want to be like,
and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement at lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those.
Wait, really? That's all she gets for lunch? A peanut butter jelly sandwich? Damn. Being incarcerated sucks. Peanut butter jelly sandwich. Actually, that's kind of like when I was in high school and you get detention. And when you get detention, the only thing that you can order from the school lunch is peanut butter jelly sandwich. You can't even get the turkey sandwich. Because usually the shitty foods are the turkey sandwich with the lettuce and the tomato and then the peanut butter sandwich. They're like, nope, you can't get the turkey. You got to get the peanut butter. I'm like, oh, the peanut butter sucks. Oh, that's not even real food. It's nasty.
Those items during a break, that she could have something like that to keep her energy level.
Does he drink coffee?
I'm asking for the court's permission that she be allowed to do that.
State, any response?
Not the state attorney's office and any of the parties involved.
Okay. I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises.
She saw the jury's lunch orders that I put her order in.
My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials.
But what kind of cookies are we talking about? Like the soft, gooey, yummy cookies, or are we talking about the hard, nasty, crunchy cookies?
So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow.
Thank you, Judge.
All right. Anything else?
This woman is on trial accused of committing a murder, and she's concerned about her snacks. Snacks.
Oh, Julie! Way to rub it in Sarah Boone's face. Julie's like, haha, bitch, I got the snacks. It's what you don't got. Damn, they actually got her a Pop-Tart. Was that a Twizzler? Oh, Twizzlers are nasty. She got the peppermint. She got the chips. Damn, Julie, she's trying to... Way to shove it in Sarah Boone's face. Someone sent her the screen grab. Oh, Julie.
She's not going to the movies. She's going to her homicide trial. And she's being specific. She's going, I want, 5 peppermints. I want to have a Pop-Tart or some cookies, 2 bags of potato chips. Get real. This lady's unbelievable. What about the sadness she might feel for her boyfriend, George?
Sadness. I'm sorry, but Julie, I don't know if you saw the interrogation video in the body cam, but there was no sadness leaking out of her. No sadness whatsoever. It wasn't until 15 minutes into the interrogation where she pretended to leak sadness.
With regard to the order tennis motion as to Ms. Boone's request for snacks, the order tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial.
Now, the part that we've been waiting for, they finally have a jury panel. Yay!
let's go ahead and bring back in our panel. We will stand. Madam Clerk will identify them by their badge number. I will ask them to remain seated where they are, and then we'll excuse the balance of the panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1a note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel.
Judge says you're allowed to take notes. I think that's about it. That's the thing that usually we wonder, are they allowed to take notes? Everything else, the rules are all the same. It's like, don't watch anything, don't look up anything, don't be trying to make conversations about the trial to other jurors, don't talk to your family members. But we have a jury panel. And again, tomorrow, because, some weird stuff happening with the defense and possible discovery violation, we're not going to start with opening statements right away. 9 o'clock, we're going to be starting with the Richardson hearing to see if there's a discovery violation from the defense. 8 o'clock, the judge does have another docket full of other cases that he's going to do. And sometimes it does run late, but I will be here tomorrow morning, 9 a.m. and the trial will start. Hopefully the trial will start, guys. I'll see you guys tomorrow. And that's about it. Also, I have other videos that we watched today. The Brian Boone interrogation video, the body cam footages from the 2019 arrest of George Torres. And there's this, oh my God, there's this wacky body cam of Sarah Boone. It's wild. I don't know. When I was watching it, I was fully creeped out. Here's a little snippet of it, okay? And that's about it. Also, don't forget to join the Discord. If you guys like, we have a true crime section. If you want to talk about true crime stuff, anything about this case, other cases, go ahead and do it in there. I put my notification up when I'm about to go live in the Discord. Have your notifications for YouTube on. And then I moved my vlogs. They're going to be on my second channel. So check it out at Hey Corgi-san. And that's about it, y'all. I'll see you tomorrow. Bye.
It's the same place! So I'm guessing you called for a reason, right? She told me 24 hours.